This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about COVID again because the California Supreme Court, answering a question from the Ninth Circuit Court of Appeals, decided there can be no coverage for COVID-caused damage because the COVID virus does not cause direct physical damage to property. And the California Supreme Court therefore answered the Ninth Circuit inquiry with a note that says no, there is no coverage. In a case called Another Planet Entertainment LLC versus Vigilant Insurance Company, the Supreme Court of California on May 23, 2024, issued an opinion written by Chief Justice Guerrero, and which Justices Corrigan, Kruger, Groban, Jenkins, and Evans concurred in a response to the inquiry from the Ninth Circuit Court of Appeal. The Ninth Circuit's question was as follows, quote, "Can the actual or potential presence of the COVID-19 virus on the insured's premises constitute direct physical loss or damage to property for purposes of coverage under a commercial property insurance policy?" Close quote. The question arose in the context of a civil lawsuit filed by Another Planet Entertainment against its property insurer, Vigilant Insurance Company. Another Planet operates venues for live entertainment. It suffered pandemic-related business losses when its venues closed, and Vigilant denied Another Planet's subsequent claim for insurance coverage. The Supreme Court concluded, consistent with the vast majority of courts nationwide, that the allegations of the actual or potential presence of COVID-19 on an insured's premises do not, without more, establish direct physical loss to or damage to property within the meaning of a commercial property insurance policy. Under California law, direct physical loss or damage to property requires a distinct, demonstrable physical alteration to property. The physical alteration need not be visible to the naked eye, nor must it be structural, but it must result in some injury to or impairment of the property as property. The Supreme Court noted that the fundamental principle of property insurance contract is to indemnify the owner against loss. That is, to place the owner in the same position which he or she would have been in had no accident occurred. However, as almost all first-party property insurance provides, for there to be a need to indemnify the insured, there must be direct physical loss or damage to the property, the risk of loss of which was insured. Insurance policies, first-party property policies, do not insure property. They insure the insured against the risk of loss of that property. And if it's not lost, if there is no loss, then there's no coverage. The Ninth Circuit question and the parties' arguments required the Supreme Court to interpret the phrase direct physical loss or damage to property in the insurance policy Vigilant issued to Another Planet. The clear and explicit meaning of these provisions must be interpreted in the ordinary and popular sense, unless used by the parties in a technical sense or a special meaning is given to them by usage controls judicial interpretation. If the meaning a layperson would ascribe to contract language is not ambiguous, the Supreme Court will apply that meaning. Notwithstanding the parties' disagreement regarding the ultimate question of insurance coverage, the available authorities in California and elsewhere reflect a substantial degree of consensus regarding the meaning of direct physical loss to property. Although the precise meaning of direct physical loss to property is more contested, its general scope is readily ascertainable. Loss can simply be a more extreme form of damage, but its meaning is also broader. Loss is often used to refer to destruction and ruin, but the definition also includes the partial or complete deterioration or absence of physical capability or function, an instance of losing someone or something, and the harm or privation resulting from losing or being separated from someone or something. The plaintiff attempted to use the definition of property damage in a commercial general liability policy, since the policy with Vigilant included both first-party property and a third-party CGL coverage. However, as the Supreme Court made clear, the nature of third-party CGL insurance is materially different from first-party property insurance. Third-party coverage turns on the insured's legal liability rather than the fact of injury to property itself. Because the definition of property damage in another planet's CGL policy is materially different on its face from the terms used in its property insurance policy, the former carries little weight in interpreting the latter. The Supreme Court, after dozens of pages of analysis and citations, answered the Ninth Circuit question as follows, quote, "No, the actual or potential presence of the COVID-19 virus on an insured's premises generally does not constitute direct physical loss or damage to property for purposes of coverage under a commercial property insurance policy." Close quote. In my opinion, and I know I claimed I was sick of COVID cases and would ignore them in this blog. However, this case from the California Supreme Court answering an inquiry from the Ninth Circuit, although lengthy and detailed, was a very simple decision, establishing the COVID virus does not cause direct physical loss or damage to the property, the risk of loss of which was insured. Hopefully this decision and the decision of the Ninth Circuit applying the California Supreme Court's decision will put to rest the issue, and there will be fewer lawsuits claiming insurance companies owed coverage for COVID property damage. This video was adapted from my blog Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. If you do, you'll be given notice of every blog posting, usually 5, sometimes 6 a week, and you'll have access to the more than 4,800 blog postings. You can also subscribe to these videos at YouTube and rumble.com. They're free, and they also give you access to other videos. If you like the videos and or the blog posting, please tell your friends and colleagues about the blog and the videos and let them subscribe to the blog and the video. And as you watch, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, of subscribing to my Substack publication. Thank you for your attention.